So what I want to do is introduce our speaker today. Brian is a good friend, a fellow networker. Brian I met at a group called Jambalaya, as I've been out networking in the world of business and connecting with other businesses and other people that are out there networking. Brian introduced himself to me. I found it just full of information, and a guy that's what I think what we talked about was about, like you said, about 10 years that you've been involved in employment law in the area of telling companies and so forth what's going on, the next changes the government is coming into. They ask them to comply with as far as government regulation. And I always thought it was very important that BBJers, people that are on the opposite side of the fence from employers, had an understanding of what that meant to them. So I talked to Mike. I said, Mike, you need to have Brian in here and have Brian talk to us about that. So with no more to do, I want us to give a welcoming to Brian Kajkep. Brian.
Thank you all. Can everyone hear me okay? As Ron said, I am an employment attorney. I work mostly with companies, but also with individuals at times on employment law issues, whether it be during the application process, which is what I'm going to be focusing on here today, during the employment relationship, as well as various contract issues that arise during and even after the employment relationship. So what I'm going to be focusing on is I'm going to give you some practical tips today, but I'm generally going to be staying away from those. BBJ, of course, has a lot of good information, a lot of good coaching, practical tips on interviewing, resume building, strategies in your job search. I'm not going to be really talking about those today for the most part. I'm going to be talking about what are your legal protections, what are your legal rights during the application process, during the interview process, including background checks when you get to that phase with a prospective employer. So the first topic I'm going to be talking about today is social media use and the protections you have and the risks you have in that. I would imagine that most, if not all of us, are involved in social media. I know I am. It's a good way to network, get your name out there, know about job opportunities. A lot of companies are even posting jobs, maybe even exclusively on LinkedIn. So if you're not on LinkedIn, especially, including Twitter, Facebook, I would definitely encourage you to get on there to network, get to know people better, learn their backgrounds, and take advantage of job opportunities that are posted online. I'm going to be talking about what I call protected classes, that is, what traits are protected here in Missouri, here in St. Louis County. That would be age, race, religion, etc. And I'll be talking more in depth about those. As I said, when you get a job offer from an employer, usually they'll want to do some sort of background check into you, and I'll talk about what rights you have, what authorization you'll need for that. I also want to talk about non-compete agreements. This can be a real hassle during the phase of being between jobs. If you have a non-compete or a non-solicitation agreement with your former employer, how do you handle that when you're applying for jobs? So let's look at social media. We all know how popular and prevalent social media is. And Facebook, for the most part, can be private. Sometimes a member of the public, without having to log in, can see information on your Facebook profile or even your entire Facebook page. Certainly LinkedIn, that's much more common, that you can see your whole profile. Well, I think you need to be aware of that when you're applying for jobs, because when you send in an application, some companies have formal policies to go check that out. Other individual HR managers, maybe it won't be official company policy, but HR managers will think that it's a good idea for them individually to go do a Google search on you, see if you have a LinkedIn profile, and they'll get information on you that way. Well, I think you should be aware of that. Now, that being said, there was a big survey that was released just last month by SHRM, the Society of Human Resource Management, big human resource organization, and it was just last month. And those statistics found that only 18% of employers have formal policies to go investigate the social media background of applicants, or at least applicants that make it to a certain phase. So I can't say this is a common thing that happens, but I think you do want to prepare for it. So just make sure that you don't have anything in public view that you wouldn't want a prospective employer to see. Certain things, not necessarily offensive, but maybe a little controversial. Maybe you don't want to volunteer it, such as even something innocuous as political affiliations. Well, that may not help you in the job search, because if the HR person who's looking at your resume is of a different political affiliation and feels strongly about that, it's going to be a negative for you that it's on your LinkedIn profile. So I would encourage you to be as neutral in what's publicly accessible as you can. So there's nothing illegal about them looking. It would violate the terms of use of at least Facebook if they said, can I have your username and login? I'm going to log into your profile and check out the whole thing. Sounds unusual, but I have heard of that happening. So I would at least be prepared for them to ask. I'm not saying do that, but you don't want to be surprised at anything that would come up during the interview process. So be careful about revealing anything that can be publicly seen that you wouldn't want them to know about in the interview process. And one thing I forgot to say at the beginning is, if you have any questions along the way, please don't hesitate to ask. So let me touch on the protected classes in Missouri. Here they are. These classes are protected both under Missouri state law and under federal law. Race, color, religious beliefs, religious practices, national origin, sex, that is gender, which includes pregnancy, ancestry, age, and disability. There's other protections as well, such as workers' compensation retaliation and whistleblowing. Now, we all know we've all heard of retaliation. Retaliation means that you can't have anything adverse happen to you by an employer for exerting your rights. And this could be anything from, say, filing a lawsuit against an employer, filing an EEOC charge, encouraging someone else to report sexual harassment. Basically, if you take any action to assert your rights under one of these laws, filing a workers' compensation claim, you can't be retaliated against by your employer. Now, this also applies to subsequent employers. So if you're looking for another job, and the reason you left your old job, you believe, is because you were terminated for filing a workers' compensation claim, well, you can't be discriminated against in that next job you're applying for because you did that with a former employer. Now, as a practical matter, I wouldn't encourage you to wear that information on your sleeve, because that's certainly not going to be a positive for you, but it is a legally protected right.
Question?
Yes, ma'am.
Recently, President Obama proposed the American Jobs Act. Embodied in that act is now a new protection. An employer cannot discriminate against a person who is unemployed. Is there anything that you know of that's maybe, if this act isn't passed, is there any other avenues that are out there that you're aware of, that are, having been in human resources, I will tell you, I discriminated against unemployed people in the past, okay? I have said I am not interested in someone that has been unemployed for a period of time. That is in the past. So I know from past experience, and if we're honest, B, have you ever been there as vice president of an HR group? Neil, are you here? Did you ever go that route? You're a good guy, okay. But in all honesty, we have, and it's out there, and it's prevalent. So any comment you may have on that?
Well, those protections are being introduced as bills throughout the country. I just read last week, I think the state of New Jersey just introduced that as well. As far as I know, there's nothing pending in Missouri. So I don't think anytime soon that's going to be protected. But basically, what she's talking about is basically adding the status of being employed or unemployed as a protected class, so that you couldn't, when you're going through the resumes, the applications, you couldn't put people in the reject pile because they're unemployed. Right now, that's a market-driven issue. That is to say, you could put a positive spin on that. The HR person could say, well, this person would be ready to start whenever. You know, we wouldn't have to worry about giving 2 weeks, 3 weeks, transitioning. We wouldn't have to worry about a counter offer from a current employer about, we don't want you to leave, we'll up your salary. So the positive spin on being unemployed is that the person can start right away. The person's not going to have, you know, their current employer make a counter offer. But you're right. Right now there is nothing stopping a prospective employer from, you know, discriminating against your application because you are unemployed. I think that's all the more reason to put your best foot forward, get a good resume in order, and be well prepared for those interviews. Yes, sir.
I've read a number of times in the employment section that the way the employers generally get around that is the old quote-unquote best fit category, and you can't trace that back to age, gender, any of those sorts of things. They'll just say, well, you don't fit either culturally or your skill set doesn't fit as well as somebody else, when it very well may be the age thing or any number of other things.
Well, that's a good point, but if an employer is challenged enough in their decision, that is, if you were to challenge them and hold forth your resume, and you seem to be more qualified on paper and have more experience on paper versus the person they did hire, whether it's someone younger than you or you suspect there might be a race motivation or an age or a gender motivation, it's not going to be enough for an employer just to give an amorphous explanation of better fit. There seems to be better chemistry. They're going to need to be much more concrete than that and talk about the specific criteria they use. If they got challenged in some sort of EEOC charge or lawsuit, I can tell you, based on my experience of defending those for 10 years, they're going to need to be a lot more specific in order for it to be a plausible defense to a claim. But you're right. If you just ask them, why didn't they get the job, I'm confused, it doesn't seem logical, they're not under any obligation to explain it to you. And they can't just rely on, I got a better feel for someone. But if they did get challenged legally, they're going to need to be more specific with their criteria that they use.
The challenge would come in is if they have a history across the board of having better fits with people younger than 40 years old.
Right, right.
Brian, you know, when we look at that area, it's always a question of the discussion of, this is one of those getting that moment, you know, in my, where it slipped away from me. Let me bring that back here, guys. Hate to tell you, but it went away, so I'll come back.
Well, I'll be up here for a while, Ron. It'll come to you.
I was just going to say